Page 1, Ryan Cohen versus Aubrey Cohen.
For the record, this matter is before the court on the plaintiff's motion for immediate return of the minor child to Michigan for interim parenting time, exclusive use of the marital home. In addition, the defendant's motion for custody, child support, other relief is also before the court. This hearing is being conducted via Zoom. Present is attorney. There's three people. Susan Lichterman is the attorney representing the plaintiff, Ryan Cohen. Good morning, Ms. Lichterman.
Good morning, Your Honor. Also with me is my associate, Aaron Bowie, and my client is present as well.
Thank you. So Mr. Cohen is present. In addition, Attorney Christina Hills is present, representing the defendant mother, Aubrey Cohen, and Ms. Cohen is also present. Good morning, everyone.
Morning, Your Honor.
Good morning.
Court has read all of the pleadings and is aware of the background facts and circumstances. The parties have met with Ms. Pratt this morning from the front of the court, who has provided the court the following recommendation. The parties shall share joint legal custody of the minor child. Father shall have supervised parenting time every other weekend, Fridays at 7 p.m. until Sunday 7 p.m. supervised by the maternal grandmother. In addition, father shall have supervised parenting time Tuesdays and Thursdays from 4 p.m. to 7 p.m. Again, supervised by the maternal grandmother, and that parenting time will commence today at grandmother's home. This is a recommendation in order to be on a temporary basis without prejudice to either party. The status quo ex parte order will continue. Further, that the plaintiff, Ryan Cohen, shall have exclusive use of the marital home. The parties shall communicate via app close with permission of the district court. Obviously, there's a bond condition, presumably the district court of no contact. So Mr. Cohen will have to reach out to district court probation and ask the probation to recommend to the district court judge to modify those bond conditions to allow communication via app close, presumably only regarding the minor child. That is a recommendation. Is it necessary we schedule a review date? Counsel, if the court adopts this recommendation, is it?
Your Honor, we are not in agreement with the parenting time provision of the recommendation. And just for the record, I was not aware that the defendant's motion was up today. We were told that it hadn't been set for hearing, which is why we didn't file a response. We were specifically told that it was filed but not set for hearing. But we're not in agreement with the parenting time recommendation. We don't believe there's a need for supervised, but we're willing to agree to that. And the maternal grandmother has agreed to act as the supervisor. This child lives in Michigan. These parties live in Michigan. Obviously, the PPO and the DV misdemeanor charge will be addressed in those proceedings. And we understand that why the court wants to be cautious given those proceedings. My client has a very, very different view of what happened and the story, but most important, these parties co-parented this child her entire life. It has now been 33 days since my client has seen his daughter. He has been involved in every aspect of her life, feeding, taking her to the doctor, watching her, every aspect, bathing, and we want to get, we believe equal parenting time is appropriate. It's what the established custodial environment is, and that should not be disrupted. And given the distance, we're first one asking that his parenting time occur at the marital home. Grandma, again, if the court deems supervision on an interim basis is necessary, grandma will be there. And we're asking that today that he immediately have at least 2 overnights. Again, he hasn't seen his daughter in 33 days, that he be able to have parenting time starting today, not just for a couple hours, but overnight. And that in general, we're looking for a 2-2-3 type schedule with this, with their daughter, so that she doesn't go more than 3 days without seeing either parent, and that my client's parenting time take place at the marital home. The defendant left, and we have different views of why that happened, but here we are. But that the child is comfortable in the marital home, knows the home, and that seems to be the appropriate place for dad to have his parenting time. So we're asking, Your Honor, that you adopt a different schedule than is recommended by the friend of the court, and we otherwise are in agreement with the recommendation.
Thank you, Ms. Lichtenman. Your primary objection is as to the recommendation that the parenting time for dad be supervised by the maternal grandmother. Is that correct?
No, we're willing to accept that. We don't think it's necessary, but we're willing to accept that. And in fact, grandmother was willing to Zoom on today to tell the court that if necessary, but we want it to be not at grandma's home, but at the marital home. And we want more than just 2 or 3 hours on Tuesdays and Thursdays. We want those to be overnights, and we want it to be at the marital home. And starting tonight, we want him to see her, to be able to get her today and have her for a couple nights, as it's been 33 days, Your Honor.
Understood. Ms. Hills, I don't quite understand the reason behind the supervision, and also if in fact this is a minor child that lived in the home, the marital home, for the bulk of her life, other than the past 33 days. She's got a bed, presumably at dad's home. Why shouldn't the parenting time occur at dad's home as opposed to the home of the maternal grandmother? So I'm not sure what the conversation was with Miss LaPrade this morning.
Your Honor, we're obviously very concerned about the incident that took place at the marital home with the child present. My client was going about her business, feeding the child that morning. The plaintiff became enraged, and the domestic violence incident ensued. The child was placed directly in harm's way by father's actions that morning. And my client left with the child for the safety of both herself and the child that morning. She was covered with bruises. The child was hit with food that was thrown and nearly hit with a plate. We would like to see some level of counseling for father before there's any sort of unsupervised parenting time. I think my client had every right to leave the home for the protection of herself and the child. She is with her father in the Cleveland area at this point in time. We are hopeful that while we're asking that the court adopt the schedule that's been recommended with the supervision requirement at this time, we are hopeful that this won't last very long, that father will get some counseling and the help that we feel that is needed under the circumstances, and that we will be able to get to a more normalized schedule. But my client was obviously very upset about what happened, physically injured by his actions. And she does not trust his judgment at this point and needs some time to be able to regain that trust in him. And I think some counseling would go a long way towards that. Hopefully he's working on that in the short term. In the meantime, the recommendation from Ms. LaPrade gives dad contact with the minor child this evening. So that time frame of lack of contact, which we would indicate is not my client's fault whatsoever. That was a situation which he created. But it gives him contact right away. It gives him contact again on Thursday. He works in the Monroe area. I'm not sure what his flexibility is in terms of being able to be at his mom's house during the work week. But I think that the 4 to 7 does give him frequent contact during the week. This gives him every other weekend. And I believe my client would be open to other times as the parties could agree. The ex parte continuing that was mentioned was a status quo financial. There's also a personal liberties injunction, which would continue. There's a PPO as well, and there's a no contact provision in district court. So I think my client is well protected at this point. But if that district court no contact provision were to go away, and or the PPO were not intact anymore, then we would certainly want that personal liberties injunction to stay. And yes, communication regarding app close should be only about the welfare of the minor child. So we believe under all of the circumstances right now that Ms. LaPrade's recommendation is fair, is reasonable, and we would ask that that be followed. I have no issue whatsoever with the review hearing. In fact, I would suggest that the case be set for mediation with Ms. LaPrade or Mr. Walker. I don't have a preference. And that the court set a review hearing and a pretrial following that mediation.
The court's aware there was an incident of domestic violence, obviously between the parents. But again, is this child in jeopardy? Is dad incapable of providing for this child that's been in his home for the majority of the child's life? Well, why do we need supervision?
Yeah, it's his judgment, Your Honor. The domestic violence incident occurred when the child was sitting right next to my client. He's throwing things at her in the direction of the minor child as well. He didn't seem to have any regard in that moment for the welfare of the minor child, simply lashing out at my client. So we're very concerned about his judgment in regard to the safety of the minor child as a result of that.
Other than the incident of domestic violence, Ms. Hills, are there any prior acts or incidences that suggest that Mr. Cohen is irresponsible parent with poor judgment in providing for this child?
I'm going to ask my client that, if I may, Your Honor.
Well, absent that, the court does not see any need for supervision. I mean, he's a father and the child's been in his home. The child's bed is in dad's home, is it not? That's the only home the child is known. Why should it be in the home of a maternal grandmother? Unless Mr. Cohen has mental health issues, is incapable of feeding this child. And without something more, the court does not believe that we need a supervision.
Ms. Cohen, have there been any past instances of domestic violence, physical assault by Mr. Cohen on you?
There have been. I have not reported them to the police, but I do have a past history of him grabbing me, throwing me around in the past.
On how many
Well,
occasions?
clearly these parties should not be married, and unfortunately brought a child in this world. They have to deal with that. But again, the court's not convinced that Mr. Cohen is an irresponsible parent that cannot provide for the parent. Obviously, the parties as a parent system need to be in separate homes. And the recommendation does not deal with transportation. Who's going to transport the child?
Your
Has that been
Honor,
discussed?
It was in the maternal grandmother, I'm sorry, paternal grandmother lives about 45 minutes away from my client's father's home in the Cleveland area.
it's my understanding the paternal grandmother lives about halfway between the two homes. And we can certainly involve the paternal grandmother in transportation. We can do one party drives one way, one party drives the other way. We can meet halfway. I'm certainly open to whatever would work best.
Now, this recommendation references a maternal grandmother, not paternal. Is that correct?
No, the paternal grandmother.
It's a typo, Your Honor.
Okay, all right. I was just trying to grasp all
Sorry.
this in terms of what the maternal grandmother is involved in this. So the court believes we need to address the transportation. The court is not convinced that we need, unless I'm missing something, that this needs to be supervised. I mean, the child should be able to stay in the home that the child has spent the majority of her life, which is the home that Mr. Cohen is residing in. I'm just, maybe I'm missing something, but I don't see any reason to be supervised by the grandmother. Unless, of course, Mr. Cohen's work schedule and he wants to have his mother present to assist, that's fine. But I don't, the court does not believe I need to order that.
And again, given the distance now, if Ms. Cohen is allowed to remain in Ohio, we're again asking for a 2-2-3 schedule. Monday, Tuesday, Wednesday, Thursday, and then every other weekend, and flipping the Monday, Tuesday, so the child doesn't go more than 3 days without seeing a parent.
That is a lot of time in the car for a very young child. And I understand that my client is the one who left. However, she really didn't have anywhere else to go, and she certainly couldn't stay in the marital home under the circumstances. So I think we probably need to talk some more, Your Honor, in light of the court's inclination here.
All right, and the court believes maybe scheduling a mediation might be appropriate. The court's inclined to adopt a schedule in the interim and set a review date or a mediation date in 30 days, see how things work out. The court agrees that obviously Miss Cohen had to vacate the home. Under the circumstances, she had nowhere to place to go other than family in the Cleveland area. And it is a long time for this child to be in a car back and forth. So the court believes that the time frames on a temporary basis is appropriate. The court does not believe that the supervision is required. The court's not going to mandate that. But I'm going to have you talk with Mr. Pratt again if you talk about the transportation issue. Maybe if the paternal grandmother is willing to do it all, fine. But otherwise, if again, the paternal grandmother, is she here? Has she been consulted? She willing to do all this driving?
She was in the waiting room. We can get her, she will work with us to make this work.
Okay, maybe perhaps get her on the phone, but I'm going to talk with Mr. Pratt for another 5 minutes or so. Maybe you can also agree upon a mediation date. Mr. Pratt, if you have a schedule with you or Mr. Walker, parties can at least, maybe not settle the whole case, but at least they can talk about some modified parenting time. But I believe the current schedule is appropriate to get started with on every Tuesday and Thursday, 4 to 7, and then the alternate weekends, Friday, 7 to 7. Now, I'm not sure the alternate weekends, would that start this weekend or next weekend? If you can discuss that as well.
Your Honor, I would just ask, I understand the court's view of too much back and forth, but at least today that he be able to get the child and have her for 2 nights today, as it has been 33 days, that he not just have to go to for just 3 hours today.
Okay, let me have a talk in with Mr. Pratt, and the court will consider that when you come back. Ms. Lichterman.
Thank you, Your Honor.
All right. Morning for a review of parenting time, as well as the motion of attorney Cassandra Suter seeking to withdraw as attorney of record for the defendant Anthony Fory. This hearing is being conducted via Zoom. It appears that we have present this morning, attorney Fan Zheng. Mr. Zheng, you are with Ms. Suter's office, is that correct?
Yes, I'm an attorney at Goldman Associates.
Okay. And sir, you're Anthony Fory?
Yes, sir.
Hey, Mr. Fory, do you have any objection to Ms. Suter's office withdrawing as your attorney of record?
Yes, sir, I do.
Okay.
Do you want me to?
Have the two of you talked this morning?
No, I have not. I have not. No.
Yeah, I'm gonna have you talk before the court's gonna address this. The counsel should always talk with the client before and understand what the issue is. Obviously, I don't know if you've communicated with Ms. Suter, but I'm gonna have the two of you talk and then I'll address the matter.
Excuse me. Yeah, I've talked to her like a week ago.
Okay, I'm gonna talk with Mr. Zheng.
Okay.
And then if he can't work through issues this morning, then the court will come out and address it.
All right. Thank you, sir.
For this Zoom hearing on the defendant or the attorney Cassandra Suter's motion to withdraw as attorney of record for the defendant Anthony Fory. Again, Mr. Fory is present, as well as attorney Zheng from Goldman Associates. Mr. Fory, you've had a chance to now talk with an attorney that's also with the same office. Have you been able to resolve whatever issue existed?
No, Your Honor. I have given them a substantial amount of money for the work they have done, and we have been to one court hearing. I know that really doesn't matter, as he says. I tried setting a payment plan up with the firm, which they denied me, and I don't have another $5,000 right offhand right now. If I could do that, give them 100, 200, or 500 per month on a set day, I would be into that. But they will not give me that opportunity. And
okay,
yeah.
So have you used up the retainer fee that you paid?
Supposedly they said I did, yes, sir. I don't know where it had that.
Well, you're entitled to a statement.
What was that?
Have you received a detailed statement showing how much time has been expended?
One time, yes.
Okay. Well, Mr. Zheng, has the retainer been used up?
Yes, Your Honor. The retainer has been used up, and I know for a fact that my firm does send bi-weekly, so statements every 2 weeks to the client with their current bill. Mr. Force unfortunately has racked up an extensive bill beyond the retainer of almost $5,000. And unfortunately, when Mr. Force applied for credit with a firm, that credit was denied, and our firm is very concerned with whether continued representation of Mr. Force having that bill continuously to rack up, if we can even be able to collect on the amount of attorney fees that's owed to the firm.
All right, Mr. Forrest, did you receive a statement 2 weeks ago?
I did not. I checked my email right before I got stuff done. I've only have got one statement that I've seen. I checked my spam folders, everything else, and I did not apply for credit. I never got like a credit check or whatever. They never did like a credit check on me, I guess. I just talked with them on the phone and asked them if I could set a payment plan up, and they did deny me, but I never got a credit check.
All right, Mr. Zanka, please forward maybe if email to Mr. Forrest the last statement your office sent. Mr. Forrest is entitled to that. He is entitled to some sort of accounting.
Oh, yeah,
So at
I
this point in
understand
time, at this point in time, I want you to address that, but I want you to represent Mr. Forrest for the hearing for the review today. So in the meantime, have you talk with Attorney Nemec in front of the court, Mr. Zeng, regarding this matter, and also in the meantime, have some of your office email to Mr. Forrest a copy of the last statement. You said your office sends them every 2 weeks. So obviously, the one was sent in the last 2 weeks, he's not received it. So we send that this morning, so Mr. Forrest can look at that. So we can at least address this issue before we conclude this morning.
Okay, I will have my office do so right now.
In the meantime, I want you to talk with Attorney Nemec and Ms. Sumner regarding the attorney time issue that's before the court this morning.
Okay. Do you mind if I log off or?
Well, I'm gonna have you talk to the attorney. I'm not gonna keep Attorney Nemec waiting here all morning. This matter was set for 9:30, so I'm gonna have you talk. In the meantime, you can have somebody, some social for your office, send that to Mr. Forrest. All right. Okay. Join the breakout room. For the record, the parties have again conferred with Mr. Pratt. Mr. Pratt has provided the court with following revised recommendation is that again that father shall have parenting again joint legal on temporary basis without prejudice. Father shall have parenting time every other weekend, Friday at 7 p.m. until Sunday 7 p.m. The parties to meet at the paternal grandmother's home. Father shall also have parenting time every Tuesday and Thursday from 4 p.m. to 7 p.m. That time will begin today, June 25th. Today will be an overnight beginning at 4 p.m. until 4 p.m.
And Your Honor, we wanted to ask everyone, I understood the court's concern with the proposal of a 2-2-3 schedule with the driving, the Tuesday, Thursday, given that mom lives in Cleveland area, my client lives in Monroe and works in Oakland County, is a little difficult. So we propose that mom doesn't work outside the home currently, that at least until the review hearing, that dad have today overnight and then every weekend for the next 30 days, for the next 3-4 weeks until the review hearing, rather than those few hours on Tuesday, Thursday, if everyone's so concerned about the driving and the back and forth. And that way he has more quality time with the child, and it doesn't really, because mom is working, she has similar time with the child during the other 5 days of the week. So today, we were requesting today overnight, and then this weekend, which is already agreed upon, but then the next 2 or 3 weekends as well until we come back for the review.
Well, the parties have conferred at length with Mr. Pratt, so the court's inclined to adopt this recommendation. We'll give a review date in 30 days. Ms. Lichterman, in terms of the overnight tonight, it begins at 4 p.m. until when? It's not real clear to the court. Maybe I'm missing something. Is that until?
The overnight tonight is 4 to 4.
My client would be dropping the child off at paternal grandmother's at 3:30, as I understand it, and then being there to pick the child up sometime after 4 on, would it be Wednesday? So that the two parties do not have to have any direct contact.
And back again on Thursday?
This, yes, that's what the recommendation is. But going forward, the recommendation is only for 3 hours on Tuesday and Thursday. So we're proposing instead of those 3 hours that it be the next 3 weekends until we're back for, or 4 weekends till we're back for the review. We understand going forward, a permanent schedule wouldn't be every weekend, but it seems in this interim time, with everyone's concerns, that makes the most sense, especially given that mom doesn't work outside the home. So she's able to have the child during the week.
Ms. Hills?
Your Honor, we went back into the additional discussions with the understanding that the court was going to be ordering unsupervised parenting time, and that the court was going to be ordering the schedule that Ms. LaPrade had recommended. For the reasons that I've already stated, we are opposed to any unsupervised parenting time. And we're opposed to any additional time over what's been recommended at this point in time. We are happy to discuss things at mediation. Hopefully, Mr. Cohen will, through pretrial services, become involved in some counseling. But we still have a lot of concerns, particularly since the child was in the middle of this domestic violence situation. So my client is not inclined to agree to anything over and above what's been recommended here today.
With this recommendation that the child would be brought to dad's today at 4 o'clock and then until 4 o'clock tomorrow, then the child's be brought back again on Thursday.
Just for this particular week, would that happen on consecutive days?
And then
Seems
again
a
on
lot
Friday.
well, again, the court unfortunately doesn't have time to work through everyone's work schedules in terms of transportation. That's a revised recommendation. The court's going to adopt this. We'll give you review dates in 30 days, and then with the hope to expand parenting time, so there's less time for this minor child to be in a car. Again, the regulation: the mother will bring the child a half hour prior to father coming. So in other words, mom's going to take the child to the paternal grandmother's home. Is that correct?
Yes, Your Honor.
Okay. And will the paternal grandmother have a car seat? Presumably, obviously.
Well, Dad would. I'm not sure if Dad's taking the child back then to the marital home in Monroe, but whoever's driving the child needs to have an appropriate car seat.
Of course, that won't be an issue.
Okay, let's give a review date, 30 days. I'm going to propose a review date in about 30 days. How about July 31st at 10 a.m.? Are the parties available?
I can do that.
Yes, Your Honor, I can do that too.
All right, Ms. Peffigus, adds recommendation party to court review parenting time and any other issues on July 31st at 10 a.m.
Yes, sir.
Ms. Hills, I'll leave it to you. Ms. Lichterman, you're a very capable, experienced family law practitioner in terms of if you want to reach out and perhaps secure some mediation dates in the meantime, or you want things to settle down. I'll leave that to counsel. The court's aware of there were some withdrawals from joint accounts, but the status quo will continue regarding those expenses. For the Zoom hearings, Attorney Susan Lichterman representing the plaintiff, Father Ryan Cohen. Mr. Cohen appears to be present with Ms. Lichterman. In addition, Christina Hills is present, representing the defendant mother, Aubrey Cohen. Ms. Cohen is present. Good morning, everyone.
Morning, Your Honor.
Good morning.
The parties have conferred with Ms. Patrick. A friend of the court has provided the court fine recommendation that the party shall mediate with Joshua Walker on August 15th, 2024 at 1:30 p.m. Appear before this court for a pretrial conference immediately thereafter. And all issues that shall be reserved until the mediation is concluded. Parenting time will continue as previously ordered. The court will assume Ms. Cohen is still residing in the Cleveland area. Is that correct?
She is, Your Honor.
All right. Is the domestic violence still pending against Mr. Cohen, Ms. Lichterman?
Yes, it is. There's a pretrial August 5th.
Thank you. Or is this recommendation agreeable, Ms. Lichterman, with you and your client this morning?
In part, we had already agreed to mediate. That's no issue. Obviously, all issues will be addressed at mediation. However, in the last couple of weeks, we've been working on a revised parenting time schedule. I thought we were in agreement to adopt that. Today, we ran into a little snafu because Ms. Cohen has apparently taken a job in the Cleveland area and wanted to start the child in daycare 30 minutes further away from Monroe. And we did have issues with daycare, and we want, because there hasn't been a change of domicile granted, and we have issues with the child being in daycare even farther from dad. That's one of the issues we'll address at mediation. But in the meantime, we would like the modified schedule that we've been talking about adopted, the few hours on Tuesday and Thursday. I mean, the parenting time's been going great, but it's hard on all parties given the distance between the Cleveland area and my client in Monroe. And I'm not sure what happened, but suddenly that became off the table, and when we had been talking about it and agreed on it, and simply because we had issues with the daycare, and which won't be an issue for the next couple of weeks. So we are asking that the extended parenting time that we thought we had agreed to be adopted, and that otherwise we're fine with waiting to mediation to address the rest of the issues.
Of course, the court's not familiar with what was being proposed. It's up to the court to make a decision on that.
I'm happy to share that proposed schedule with the court. It was.
Ms. Hills, again, I wasn't sure if you were the bad. Last time we were hearing the court has a significant concern about these Tuesdays and Thursdays. That's a lot of time. This 2-year-old child going back and forth, spend more time in the car than spending time with dad. And that's this court's concern with the interest of that children, that child. So for modified parenting time, maybe we should look at maybe Tuesdays, Thursdays, and maybe use more time on the weekends.
Well, that's what we were trying to do. Dad was going to have Mondays, specifically Mondays, because the child had been in a swim class on Mondays with cousins, and that would allow him to continue in that swim class. And the schedule was going to be Dad would have every Monday from either if it was part of his weekend, if it wasn't his weekend, from 6 p.m. on Sunday to 6 p.m. on Tuesday. Mom would continue to have all Wednesdays and Thursdays, and then they would alternate the weekends. Dad would start Friday at 6 and go through Saturday at 9 a.m.
No, I think maybe Ms. Lickerman and Ms. Patrick and myself could use a breakout room. What Ms. Lickerman just argued is substantially different from what I last heard, and that was that Dad was going to be making an argument this morning that my client returned with the minor child to the marital home. He indicated he would be happy to vacate. And we had some discussions about an alternate parenting schedule, but the rug again was pulled out from under us this morning because the discussions, which we don't normally even get into with the court, centered around an agreement that my client be able to stay in Cleveland area at least on a temporary basis. We understand that the court is not allowed to change the domicile as of yet. I'm working on that motion that will be filed shortly. That is going to be an issue in this case. In the meantime, my client has a right to work and support herself and the minor child. She also has a right to daycare for the minor child. We have provided Dad with a list of potential daycares. He has indicated that there was one that he was satisfied with. I believe that's the one that he's now complaining is a half an hour further away. But he can't stop my client from working while this case is pending to support herself. We understand she may be starting this job if the court declines to authorize a change of domicile. She may be moving back to Michigan with a minor child at some point. We don't know when this case is going to be concluded. We don't know how exactly it's going to be concluded. But in the meantime, my client has a right to daycare for the child while she works, and she has a right to work. So if we're talking about now not having an argument today about her staying in Cleveland, then I'd be happy to talk to Ms. Lickerman. I think my client would be okay. That's what she indicated by a nod or a shake of her head to talk about that parenting time change because she's concerned as well about those evening parenting times.
Right. You want to discuss that further this morning, Ms. Lickerman, or wait till this mediation date?
No, of course, Your Honor. I indicated we would be returning the child to Michigan if we were arguing in front of you today where the child should be in daycare and even the domicile. We were more than willing to put everything into mediation, but then when Ms. Patrick came back, she indicated that the recommendation was put into mediation without expanding the parenting time. So that which made no sense because everyone had agreed on the expansion of parenting time. We did not agree on this daycare. It was just told to us that last week that there were 4 options, and then 2 days later that Ms. Cohen had picked one. This has been an issue all along. We don't consent to a change of domicile. So yes, I'm prepared to only address the expansion of parenting time that we thought was agreed on, and otherwise everything else we'll deal with at mediation. Domicile, daycare, everything. That's what mediation's for.
Is this mediation date too soon? The court suggested to Ms. Patrick that she discuss with the parties the possible mediation date. Based on what's happened in the past, the court it appears that reconciliation is perhaps unlikely. And I thought we need to move the matter forward. If in fact you want to mediate sometime in September, October, we can do that as well. If the parties think there's a chance of reconciliation, you want to just talk about parenting time, we don't need to mediate. I just thought try and move it forward for the best interest of the child.
Your Honor, my client has indicated to me, and we've reiterated that to Ms. Lickerman and her client, that at least at this point in time, there is no opportunity for reconciliation. So we are moving forward. I believe we set the mediation at the last hearing date. I would like to sit down at mediation and see what we can agree to, at least what the areas of disagreement are. I believe we've both exchanged financial disclosures at this point, so we have the financial information that we need to be able to at least make some progress at mediation. Again, even if it's just defining what our areas of disagreement are.
I agree with Ms. Hills. I think we should at least start the mediation, and especially with these interim issues of parenting time. And again, my only request was pending the mediation, which is now just a couple weeks off, that we do tweak the schedule as we've been discussing.
And on the assumption, and perhaps the court can help with this, that my client is going to be able to stay in Cleveland, the Cleveland area, at least until a resolution is reached regarding our motion to change domicile, then I think under those circumstances, my client would be willing to talk about the modification of parenting time this morning.
Well, I cannot consent that she can stay there till the motion to change domicile is resolved. That likely will be part of the trial. Generally, a prejudgment motion to change domicile, we have to have a full evidentiary hearing. That's going to be for a while. At this point, I thought we were just putting a band-aid till mediation, something we'll discuss at mediation with the right to either party to come back to the court to address interim issues. Again, I'm just looking to fix the schedule that both parties agree needs a little fixing until we get to mediation and can discuss more long-term issues.
And
due to the fact that the circumstance under which Ms. Cohen vacated the marital home, namely alleged domestic violence perpetrated by her husband, and the fact that the child's not of school age, the court's not going to order her to return to Monroe County at this point in time. I mean, it'd be different if the child was in 3rd grade and we need that consistent continuity. So that's when the court would be perhaps inclined to order the child to return to school. The child is what, a year and a half? Just as far as it's daycare, so it's not a school. If that were the case, the court would order her to return, but I'm sure the court will not order her to return to Monroe County at this time. And that would be left for a motion to change domicile. Can have a full evidentiary in that matter, but based on those factors, circumstances under which she vacated the marital home, age of the child, the court's not going to order that the child be returned to Monroe County at this time. So with that, do you want to talk any further with Ms. Patrick regarding modified parenting time between now and August, or do you want to wait till August 15th?
Your Honor, we're here on the review. When we were here last time, you indicated that you, if everything went well, you believe that parenting time would be expanded. We've agreed on the expanded schedule. In terms of returning the child, that need not be decided today, but there are many reasons besides school to return the child.
Further argument. The recommendation is that parenting time continues to be majority. If you want to discuss it further, I'll put you back in the record with Ms. Patrick. And if you cannot agree, then the court will arguments and make a decision this morning. But the court's already made a decision. The court will not order the child to return to Monroe County at this point in time.
Okay, that's fine.
right. If we
So
can
we'll talk to Ms. Patrick, then talk about parenting time for the next couple of weeks. You've heard the court's concern about this child going back and forth, I believe every Tuesday and Thursday. A lot of driving. So if we modify parenting time, can reach some agreement, that the court may very well strike that provision. So with that, I'm talking to Ms. Patrick.
Yes, Your Honor.
Thank you, Your Honor.
Calling this matter after the parties having met again with Ms. Patrick regarding the parenting time between now and the scheduled mediation of August 15th. The recommendation is as follows: that parenting time for plaintiff files should be as follows. Week 1, files should have parenting time Sundays at 6 p.m. until Tuesday at 6 p.m. Week 2, Saturday 9 a.m. until Tuesday at 6 p.m. All changes will be done at the paternal grandmother's home. The parties are to have no contact. The grandmother will drop the child off 1/2 hour before the exchange time. In parenting time, the plaintiff father will return the child a 1/2 hour before the exchange time at the end of the parenting time. That's a revised recommendation. Ms. Lichterman, is this a revised recommendation relative to parenting time agreed with your client this morning?
Yes, it is, Your Honor. Thank you.
Okay, Ms. Hills?
Yes, Your Honor. The only thing we didn't discuss is when this starts. Aubrey, whose weekend is coming up?
It'll be mine, and if they're in agreement, I'm okay with doing one last evening visit this Thursday to wrap up that.
That's fine.
Okay. All right. As long as we're on the same page.
Right, thank you.
Yes,
Okay,
it is agreed, Your Honor.
Where is the paternal grandmother's home? In Monroe County?
She is fortunately in between Monroe County and the Cleveland area.
Okay,
Where
good.
where is she, Aubrey? About halfway?
About 45 to 50 minutes from me.
Sandusky area?
Correct.
All right.
And this is where we've been exchanging up till now. So that's a continuation of the prior order.
Well, at least my child can see his grandmother. That's wonderful.
Yep.
It's good for everyone. All right, Ms. Lichterman and Ms. Hills, either of you want to voir dire your respective clients regarding this recommendation this morning?
I don't need to, Your Honor.
And I'm fine as well. They're both on the Zoom and have indicated their acceptance.
Okay, very well. Thank you, Ms. Lichterman, Ms. Hills. And the court would like to thank Ms. Patrick for fine assistance this morning. The court will adopt the recommendation, and we'll see everyone after the August 15th mediation with Mr. Walker. And for the record, this matter is before the court on the defendant's objection to the ex parte order entered by this court, as well as plaintiff's motion for temporary custody of the relief. This hearing is being conducted via Zoom. Present is Attorney James Petrangelo representing the plaintiff Sean O'Hearn, and Mr. O'Hearn is present. In addition, Attorney Lawrence Smith is present representing the defendant, Mother Brianna McCarroll. Ms. McCarroll is Ms. McCarroll present on audio?
She was here actually via video and audio. I'm not sure where she went. I apologize.
Okay, we'll give her a moment. The court would note for the record an ex parte order was entered by this court on May 20, 2024, prohibiting defendant mother from removing the two children from plaintiff's care, pending this hearing today. Mr. Petrangelo, before we begin, your complaint is for one of custody, not divorce.
Correct, Your Honor. It appears inadvertently it was assigned a DM designation in the case number. I certainly can prepare a stipend order with counsel to seek to have that corrected.
Just converted from a DM to a DC. If you can do that, Mr. Petrangelo, take the initiative.
Yes, I will do that.
I'm not sure who's opening these files. They obviously couldn't have been any clearer. Complaint for custody, not divorce.
It's just force of habit. I'm sure somebody just didn't even think about it and assigned the number.
It's pretty fundamental. They should be thinking about them.
I'll submit a stipend order.
Thank you.
Happy to sign.
Do you want to text your clients, Ms. Smith, and see whether they ever get back on?
Yep, I just did actually, and my office left her a voicemail. I'm not sure where she went. I do apologize to the court. She was here the whole time.
No problem. And I apologize. We're a little bit running behind this morning. While we're waiting for her, for Ms. McCarroll to appear, the recommendation of Ms. Patrick this morning is that the party shall mediate with Mr. Walker on August 14th, but then appear for review on August 27th. Why can't we just appear before the review after the mediation of August 14th? Is there a reason why we're putting the review out 2 weeks after the mediation?
Your Honor, I was just putting that in case we don't come to resolution on the mediation, but the attorneys are aware that if they do get a resolution, a mediation, that we would be able to put that on the record for them.
Okay, the court will be available. If you need the court's assistance after that mediation, we can Zoom right up here. Certainly, if we have an agreement, we can put that on the record on that date and vacate the August 27th.
Thank you, Your Honor. Ms. Smith, are you comfortable announcing the agreement? I know your client was here and seemed okay with it.
Yes, so she was okay with it. We talked in a breakout room as well. I would be comfortable placing on the record. I do apologize. My office is repeatedly calling her right now. I don't know what happened. It is storming pretty bad. I don't know if it is in Ohio, but I do apologize, Your Honor. I'm not sure what happened.
Very well. The recommendation of Ms. Patrick this morning is the party shall share joint legal custody of the two minor children. Defendant mother's parenting time will be alternating weekends from Fridays at 7:45 p.m. until Sunday at 7 p.m. Also every Wednesday from 7:45 p.m. until 5 p.m. Defendant mother's parenting time shall take place at the maternal grandmother's home. The party shall mediate with Mr. Walker via Zoom on August 14th, 2024 at 1:30 p.m. In fact, I'm just going to vacate the August 27th. Sometimes I'm having a hard time finding prompt, timely hearing dates for other cases. So I'm going to eliminate this August 27th. Ms. Patrick will just say the party shall appear before the court subsequent to the August 14th. Just say the party shall attend mediation with Mr. Walker on August 14th, 1:30 p.m. and subsequently appear before the court for review. We'll strike and eliminate this August 27th date. Finally, the issue of child support should be referred to the front of the court for formal investigation recommendation with each side to have 21 days in which to object. That is a recommendation. Mr. Petrangelo, is this recommendation agreeable with your client?
It is, Your Honor.
Ms. Smith, is this recommendation agreeable with your client?
Yes, it is. Thank you.
I'm sorry, it also says plaintiff father will do all transportation. That was an additional condition.
That is agreeable, Your Honor.
All right, so the court's going to adopt the recommendation, and parties can appear before the court. The court will be here on August 14th, I believe, right? Okay, so we'll just appear for review after the August 14th, the mediation with Mr. Walker, and we'll strike the August 27th date. Oh, there's Ms. McCarroll.
Hi, I apologize.
That's right, Ms. McCarroll. The court just read on the record. I'll read it again. The recommendation of Ms. Patrick this morning is that the two of you shall share joint legal custody. Your parenting time shall be alternating weekends, 7:45 a.m. until Sunday, 7 p.m., as well as every Wednesday, 7:45 a.m. to 5 p.m. Your parenting time shall take place at the maternal grandmother's home. Every other weekend. Will that start? Will the Wednesday start this week?
Yes.
Yes, it does.
And okay, Bob, what about the alternating weekends? Will that start then this weekend or the following weekend?
This weekend, Your Honor.
Correct.
Father will do all the transportation. The parties will mediate with Mr. Walker on August 14th at 1:30 p.m. and subsequently appear before the court for review. And the issue of child support shall be referred to the front of the court for a recommendation, with each party having 21 days in which to object to that recommendation. Ms. McCarroll, you're obviously aware of the recommendation, correct?
Yes, sir.
And Ms. Smith indicated in your absence that you were agreeable with this recommendation. We can review everything when we come back then on August 14th.
Yes, sir.
Right. Ms. Smith, counsel, did either on the board, your respective clients regarding this recommendation? They did participate in the discussions.
Yes, I would love to, if you don't mind, Your Honor.
All right, Ms. McCarroll, Mr. O'Hearn, can you both raise your right hand to be sworn? Mr. O'Hearn?
Yes, sir.
Thank you. We need to capture responses. All right, Ms. Smith, if you're going to begin.
Thank you, Your Honor. Brianna, do you understand the agreement that we reached today and all the terms that we reached in our discussion with the friend of the court, as well as the attorney and your ex-boyfriend?
Yes, ma'am.
And are you entering into this agreement of your own free will voluntarily with no pressure from anyone else?
Yes, ma'am.
And do you understand this agreement is only temporary and that you do have a right to have a hearing?
Yes, ma'am.
And are you in agreement with mediating this issue on August 14th with Mr. Walker?
Yes, ma'am.
Okay, nothing further.
Mr. Petrangelo, do you have any questions of Ms. McCarroll?
I do not, Your Honor.
Any questions of Mr. O'Hearn?
Yes, briefly. Mr. O'Hearn, do you understand the agreement?
Yes.
And you understand we could have asked that the court schedule a hearing now. Do you understand that?
Yes.
And knowing that, are you in agreement with the recommendation that's been placed on the record today?
Yes, sir.
I have no further questions, Your Honor.
Ms. Smith, do you have any questions of Mr. O'Hearn?
I do not, thank you.
Very well. The court finds agreement to be in the best interest of the minor children. The court will accordingly adopt the same. And we'll see one back on August 14th after the mediation with Mr. Walker. Right, that concludes your review. Subsequent parties have engaged in mediation with Mr. Walker for the front of the court. This hearing is being conducted via Zoom. President is Attorney James Petrangelo, representing the plaintiff. Father Sean O'Hearn. Mr. O'Hearn is present. In addition, Attorney Lawrence Smith is present, representing the defendant mother, Brianna McCarroll. Ms. McCarroll is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Begin by please reminding the council this is a DC case. Mr. Petrangelo, I know you filed another pleading and it's got DM, and where everything piece of paper is filed has got DM, and there's an order in or stipulated order, and that's a DC case. So please make Big red mark on your file. DC.
Will do, Your Honor.
We're continuing the confusion.
Okay.
So with that clarified, have the parties reached some agreement on their own this afternoon?
Yes, Your Honor. This is a complaint for child custody. We reached an agreement as to the terms for a final judgment. And with the court's permission, I can announce that.
Please.
Yes, Your Honor. The parties have two minor children, Zoe, age 6, and Mackenzie, age 4. They've agreed to have joint legal custody of those children. We would not specify any award as to physical custody. We would spell out parenting time as follows. Mother will have, during the school year, every Wednesday from after school until delivering the children back to school on Thursday. On the weekends of each month, on the first weekend, she would have the children from Friday after school until delivering them to school on Monday. The second weekend would be Father's. The third weekend would be Mother, again from Friday after school until Monday to school. The fourth weekend would be Mothers from Friday after school until Sunday at noon. The fifth weekend would be hers also from Friday after school until Monday to school. If for whatever reason during the school year there is no school in session, the pickup and return will be to daycare. During the summer months, they will alternate on a rotating 3 days for Mother, 4 days for Father. The next week, the opposite, 4 days for Mother, 3 days for Father. The parties will set those days and times by agreement. They both believe they can do that. Mother has agreed she will, to the extent possible, take weekdays during the summer to alleviate daycare costs. They would share holidays by agreement. They do not wish to adopt the friend of the court holiday schedule. During the year, each party is entitled to 2 non-consecutive weeks of uninterrupted parenting time. That can be at any time throughout the year as long as they are not removing the children from school. So if someone wants to exercise it on a spring break, for example. They will currently reserve child support. They will divide on, Mother is covering the children on medical. Uninsured medical would be paid 62% by Father, 38% by Mother. Father will pay daycare at the current financial level. The income tax deductions for the minor children, each would take 1 child. When there is only 1 available to be claimed, Father will be entitled to claim the child for odd numbered tax years and Mother for even numbered tax years. I believe that is their agreement.
Mr. Petrangelo, I'm sorry if you mentioned this. Where will Zoe be attending school?
Jefferson.
Okay. Thank you, Mr. Petrangelo. Ms. Smith, did Mr. Petrangelo accurately state your client's agreement?
Yes, Your Honor.
Wonderful. Mr. O'Hearn, Ms. McCarroll, can you both raise your right hand and please to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. All right, Mr. Petrangelo, if we're going to begin with Mr. O'Hearn, please.
Yes. First of all, Mr. O'Hearn, did you hear the agreement I placed on the record?
Yes, sir.
Do you understand it?
Yes, sir.
Are you in agreement with those terms?
Yes, sir.
Do you understand you could have a hearing in this matter and the judge might do something totally different than this and you are giving up your right to that hearing?
Yes, sir.
Do you believe that these provisions are in the best interest of your children?
Yes, sir.
Do you believe you and Ms. McCarroll can cooperate on parenting time issues for all those areas we've left open for discussion between the two of you? Can you do that in the best interest of the children?
Yes, sir.
And you are satisfied with the children attending school at Jefferson?
Yes.
And you have been residing, we've alleged in the complaint, with the children here in Monroe County for at least the last 6 months?
Yes, sir.
I have no further questions of my client.
Thank you, Mr. Petrangelo. Ms. Smith, do you have any questions, first of all, for Mr. O'Hearn?
I do not.
Questions for Mrs. McCarroll, please.
Thank you. Brianna, did you hear the settlement that was placed on the record today?
Yes, ma'am.
Do you understand the settlement that was placed on the record?
Yes, ma'am.
Did you voluntarily agree to this settlement with the plaintiff in this matter?
Yes, ma'am.
Do you believe the custody and parenting time and child support provisions that you've agreed to are in the best interest of your children?
Yes, ma'am.
Do you believe that you and your child's father can make important life decisions regarding your children together?
Yes, ma'am.
Do you understand that you're not agreeing to adopt any type of default provision, including the FOC holiday schedule, in your agreement?
Yes, ma'am.
Do you understand that custody, parenting time, and child support are modifiable until your children reach the age of 18?
Yes, ma'am.
Do you understand that you had a right to a trial in this matter where we could have had a ruling that was more favorable, less favorable, or substantially similar to what you agreed to today?
Yes, ma'am.
And are you in agreement to waiving your right to have a trial in this matter and reach a settlement today?
Yes.
Are you satisfied with the efforts of your attorney in this matter?
Yes.
Do you have any questions for myself or the court today?
I do not.
Nothing further, Your Honor.
Thank you, Ms. Smith. Mr. Petrangelo, do you have any questions of Ms. McCarroll?
I do not, Your Honor.
You'll prepare the order, Mr. Petrangelo?
I will.
Thank you. And if you can, when you dictate that, if you can inform your staff for that, to make sure the case number ends in DC, please.
Yes, I've underlined that a couple of times on my notes, Your Honor. I will do that.
Thank you. Thank you. The court would like to acknowledge Mr. Walker for his assistance, and particularly attorneys Smith and Petrangelo for helping their respective clients reach their own agreement. And the court applauds the two of you, Ms. McCarroll, Mr. O'Hearn. It's wonderful. You can co-parent your two children, work together without question. It's the best resolution. The court applauds you for finding that middle ground. And rest assured, there'll be some challenges in the future, but they can be addressed through effective communication. So please keep that in your mind. This is your children do well if you're on the same page for their benefit. The court finds your agreement between the best interest of minor children. The court will accordingly adopt that agreement and enter the order upon presentment. Good job, Mom and Dad.
Thank you.
Thank you again, Ms. Smith and Mr. Petrangelo. That will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you,
You're
Your Honor.
welcome. Court to review parenting time as well as the motion of Attorney Cassandra Suter to withdraw the attorney of record for the defendant, Anthony Fory. The court previously had conversations with Mr. Fory and Mr. Zeng, appearing on behalf of Ms. Suter. The parties have conferred with Mr. Pratt from the front of the court, who provided the court with the following recommendation. That father shall have a parenting time as follows. Saturdays from 10 a.m. to 3 p.m. And the minor child should not be more than 1 hour away from Monroe. Father shall have pace times as the parties can agree. Issue of child support shall be referred to the front of the court for formal investigation recommendation, with each party having 21 days in which to object to any recommendation. Any child support ordered ultimately shall be effective March 1st, 2024. Issue of credits for direct payment shall be reserved for future considerations. Finally, the party shall appear back for its court to review father's parenting time on September 17th, 2024 at 10:30 a.m. That is the recommendation. Ms. Nimick, is this recommendation good with your client?
It is, Your Honor.
Mr. Zeng, is this recommendation good with your client this morning?
My client is indicating no.
Okay.
I would like to
And
get
what are his objections?
Yes,
He's objecting to him not being able to get overnight parenting time, and the fact that he has been providing support for the minor child, but the backdating of the child support would put him in a significant arrearage.
Right. The issue of credits is reserved. So Mr. Fory, you should not make any direct payments. That should be through the front of the court. And if in fact you're seeking credits against child support, that can be addressed at a future date. So that issue is reserved. With respect to parenting time, we have the minor child is what?
11 months.
11 months old, not even a year old.
Correct.
Ms. Nimick, what's your client's objection to overnights?
Currently, Mr. Forrest lives 2.5 hours away and does not have a home of his own. He indicates that he is living with friends at a house that, when I look it up, it is a 2-bedroom, 1-bathroom house that already has 3 occupants, not including Mr. Forrest. Mr. Forrest has never exercised any overnight parenting time, has never provided care for River independently. And when Ms. Sumner speaks to Mr. Forrest, because they do FaceTime every day, as he just indicated, he is never at the home that he claims that he lives at, and is instead in a shop that he was previously living above that has no running water or bathroom. So at this point, he again has never exercised any overnight parenting time. Previously, his parenting time was supervised by Ms. Sumner. The appropriate next step would be for him to have unsupervised parenting time, not go straight from supervised parenting time to overnights 2.5 hours away.
Your
All right,
Honor.
thank you.
Yes, Your Honor. The parties are actually only an hour and a half away. The residence that my client is residing in has been remodeled with 4 bedroom and 2 bathroom, and the family that he is intending to live with, their daughter is about to move on to college, so there will only be 2 occupants left in that home, excluding Mr. Fory and potentially the minor child.
Well, if the court recalls, in the past, Mr. Fory has been homeless and he's been bouncing around. So until such time Mr. Forrest secures some permanent, appropriate housing, the court will not permit overnight parenting time. So Mr. Fory, that should be your first focus, is getting some appropriate housing.
Yes, sir.
Which is appropriate for overnight. So we can review that issue on September 17th at 10:30 a.m. So the court's inclined to adopt this recommendation, and it gives a little more freedom from the prior order. Rather than restricting it to mile and dragway, you can,
right.
You don't, as long as you're not more than 1 hour away from Monroe. And of course, summertime, you go to parks and so forth.
Yeah, I was really just right now, Your Honor. I was just really wanting a set day each day, like 5 to 6 p.m. where I could FaceTime River, at least if I'm not going to be able to do parenting time and exercise my parenting time and my rights as a father, Your Honor.
Okay, so you want a specific time for the FaceTimes?
Yes, sir.
Well,
Okay,
Your
Ms.
Honor,
Nimick,
I work until 4:30 p.m. and I work a half an hour away. So sometimes I do not get to River until 5 or just after.
So let's say 5:30, 6 o'clock. What's a good time, Miss Summer?
6 o'clock should be fine.
Work with your schedule, Mr. Fory?
Yeah, she goes better around 6:30. I was kind of leaning toward like 5:30 to 6 or 6:30.
She does not go to bed at 6:30.
Oh, she's not? No, I thought she was. Okay.
It's always been between 7 and 8.
Every time, I mean, a lot of times I've talked to you, Ash. I see her sometimes sleeping at 5:30, so that's kind of.
It depends if she napped or anything all day.
Your Honor, if I may, Ms. Sumner has been facilitating FaceTimes between Mr. Forrest and River nearly daily, which he admitted himself when we were before Ms. LaPrade. What he's looking to do is try to hold Ms. Sumner to a time that he can enforce, rather than understanding that an 11-month-old and parenting an 11-month-old basically on her own requires some flexibility.
No, ma'am, that's not what I'm trying to do.
Well, if I could, Your Honor, I believe my client's asking for a range of time, not exactly exact time period. So my client was stating from 5 to 6 or from 6 to 6:30, sometime in between that time when, Ms. Sumner is available, she could facilitate that video call or that phone call for my client and the manager. So we don't exactly need to say exactly at 6 p.m. that Ms. Sumner needs to be stay by the phone, but when Ms. Sumner is free between 6 to 6:30 or 5:30 to 6:30, she could give my client a call with the manager to facilitate that that contact.
Right. So it's unfortunate. The best schedule is one that they can agree upon, but if they can't, then we establish a time frame. So what, between 6:30 and 7? Mr. Fory, Ms. Summer?
I'm fine with that, but sometimes,
Okay.
she is 11 months old. Sometimes she doesn't agree to be on the phone.
So you understand, Mr. Fory, it might be about a 60-second FaceTime if in fact you're going to hold her to a certain time frame.
No, Your Honor, I'm not trying to hold her to a certain time at all. I mean, I'm cool with it from 5 to 7. If we can set that schedule, what time she wants to call me, if she wants to call me at 6:39 or 6:59, it's fine. Just
So she's not home till close to 6 o'clock. So what, say between 6 and 7? Is that what you're suggesting?
yes.
All right, Ms. Nemec?
Ms.
Summer, would that
Sumner,
work?
you've indicated a couple of times that you don't have a problem with that. Is that accurate?
Yes, we've been calling him before bed. That's completely fine.
All right. So the court will order the FaceTimes, they occur between 6 p.m. and 7 p.m. every day. Otherwise, court will adopt the remainder of the recommendation, and we'll be back to review these issues September 17th at 10:30. Lastly, Mr. Zeng, your office's motion to withdraw. Have you sent to Mr. Fory a copy of the last statement?
I did. I have sent Mr. Forrest a detailed statement containing every single charge from the beginning of the case to now.
All right, Mr. Fory, did you receive that statement?
I did, sir. It is 19 pages long. I tried to look at a couple. It's probably going to take me an hour or two to review, where I can look at all my emails I sent and what they have wrote down, Your Honor. See if it's accurate. Sorry.
You can obviously, there's been a breakdown in the attorney-client relationship. So if in fact you have issues with that, you need to take it up with their office. You have certain civil rights as well if you want to file civil action if they are breaching their contract. But the court is at this point inclined to allow them to withdraw as your attorney, which means you can hire a new attorney to represent yourself. Do you understand that?
Yes.
Anything else on that issue?
On the withdrawal issue?
Yes.
You're saying they're not going to be my attorney? Right
sorry?
after. Did you say they're not going to be my attorney after today?
Correct.
Okay. Yeah, I was just wondering. I mean, I didn't know if you looked at it. The substantial amount of money that I have gave them, and we have been now, 2 court hearings. I've tried making a payment plan with them, and I have got denied a payment plan. And
okay. That's between you and that office. That's between you and the Goldman Associates. The court's not going to get involved in the middle of that. So at this point in time, the court will allow Goldman Associates to withdraw as attorney of record for Mr. Fory's. Mr. Zeng will need an order to that effect, and also put in that order the current mailing address.
There should be a proposed order attached as Exhibit A. If you do not have that,
it's in the file. I don't take the orders out of file. You should submit that separately rather than attach it to your motion. So I can't take it out of the file. You need to resubmit that.
Okay.
I do see, yes, it does have an address. Mr. Fory's, your current address is 1795 West Barnes Road, Fostoria, Michigan. Is that correct?
yes, sir.
All right, so all for free pleading. So that order, I just can't pull it out of the file. Mr. Zeng, you've got to resubmit that order.
We'll do so.
But it appears that has Mr. Fory's address, mailing address reference that order, so that should be sufficient. So the court will grant that motion and will enter the order upon presentment.
Thank you, Your Honor.
Anything further, Ms. Nemec?
I have nothing further. Thank you.
Okay, so Mr. Forrest, reach out to Suter or Goldman or whoever you need to deal with that firm. After review the statement, if you have concerns, and either represent yourself September 17th, note on your calendar, or get another attorney.
Alrighty. Thank you, Your Honor.
All right. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you very much.
For the record, this matter is before the court for the purpose of reviewing defendant mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Derek Jacques, representing the plaintiff father, Tyler Zanka. Mr. Zanka appears to be present with Mr. Jacques. In addition, the defendant mother, Kelly DeMerchant, also is present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred with Ms. Patrick from front of the court this morning. Ms. DeMerchant, have you been released from Sacred Heart?
Yes.
Okay, successful discharge?
Yes. I went back a couple of times for preventative measures there. So I stayed there until April. Mm-hmm.
Are you currently involved in aftercare?
Yes, sir. Yes.
The last order of the court was on March 12th that you were getting supervised parenting time at Family Counseling Shelter Services. Has that commenced yet?
Yeah, I only had one. I had several encounters at Sacred Heart with my son as well, where Mr. Zanka dropped off Jack, and I met with him in a separate corridor to meet with Jack, but they couldn't get me into Family Counseling and Shelter Services until Jack completed school, which was June 11th. And then I had the one commencement with Jack, which was June 17th, and they could have got me in on June 24th, but then I had court the next day. So it was kind of a struggle because I have a newborn as well. So they said that it would not.
The rec is in your queue, Your Honor.
Thank you, Mr. Merchant. The court has now received the recommendation from Ms. Patrick, which recommendation is as follows: that mother shall have parenting time as follows during the school year. Parenting time for mom shall be Friday after school or 4 p.m. if no school until Sunday at 3 p.m. During the summer months, mother shall have parenting time on Sundays at 3 p.m. until, it must be a typo there, Ms. Patrick. Should I say Saturday at 3 p.m. until Sunday at 3 p.m.?
Sunday to Sunday.
Your Honor, they're doing week to week.
Oh, I see.
Summer.
Whole week, I see. So it's essentially it's a week on, week off during the summer. Sunday, mom shall have Sunday at 3 p.m. to Sunday, the following Sunday at 3 p.m. Holidays, the parties can agree. If they cannot agree, then the fallback will be the front of the court holiday schedule. Each parent will pick up the minor child, give their respective parenting time. Lastly, the child will remain in the airport school district. That is the recommendation. And Ms. Jacques, is this recommendation good with your client this morning?
Yes, it is, Your Honor.
Thank you. Mr. Merchant, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting the recommendation?
Absolutely not.
Do you believe this is in the best interest of your child?
Yes, I do.
Right. Mr. Jacques, after your client participated, do you want to voir dire your client regarding this recommendation?
Absolutely, Your Honor. Mr. Zanka, did you hear the recommendation I was placed on the record? I did. And is that the agreement that we came to with Ms. Patrick and Mr. Merchant? It is the agreement. And do you believe that at this very point in time that recommendation regarding parents' time and custody is in the best interest of your son? I do. I have nothing further, Your Honor. Thank you.
Thank you, Mr. Jacques. The court finds the agreement to be in the best interest of the minor child. The court will going to adopt the agreement. Mr. Merchant, you've come a long way. So the court congratulates you. Stay strong. It's important that you continue with aftercare. You want to maintain sobriety for the benefit of your child who's 5 years old and going to be growing up quickly. So when will the Sunday start? Will that start this Sunday, Mr. Jacques?
Yes, well, Your Honor.
Okay. All right. So please communicate, the two of you. Obviously, there's enough challenges in life. Communicate for the best interest of your 5-year-old. And the court, with pleasure, will adopt the recommendation. That will conclude this hearing. No need for reviews. All right.
Your Honor.
And Ms. DeMerchant, make sure you keep the front of the court informed of any change of address. It's real important that everyone knows where you're living. Okay.
Okay. Yes, no problem, Your Honor.
Because the front of the court will mail you a copy of this recommendation, which will become an order of the court. All right. Thank you, Mr. Jacques. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor. You too.
For the record, this matter is before the court for the purpose of reviewing plaintiff mother's parenting time as well as addressing a school district issue. This hearing is being conducted via Zoom. Our President Attorney Ronald Bruce, representing the plaintiff mother Rebecca Alexander. Ms. Alexander is present. In addition, defendant father Jake Gladen is also present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred this morning with Ms. Pratt from the front of the court, who has provided the court with the following recommendation: that mother's parenting time shall be every other weekend, Fridays at 6:30 p.m. until Sunday at 6:30 p.m. The person beginning parenting time shall transport the minor child. In addition, mother shall additionally have additional parenting time on Tuesdays from 6:30 p.m. to 8:30 p.m. in the Westland area. The child shall remain in the Wayne Westland School District by agreement of the parties. Further, both parties shall have a 1-week vacation during the summer with 14 days advance notice to the other. And holidays shall be as agreed. If we're unable to agree, the fallback will be the Monroe County Friendly Court holiday schedule. Court's pleased that the parties have agreed on the school district. That's very important. All right, Mr. Bruce, is this recommendation good with your client this morning?
Yes, Judge.
Thank you. Mr. Gladen, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting the recommendation as an order of the court?
No, Your Honor.
Right. Mr. Bruce, do you want to voir dire Ms. Alexander regarding this recommendation? She did participate in the discussions.
I can. Ms. Alexander, you heard the agreement we placed on the record with the judge, right? Was that a yes?
Yeah, I'm sorry.
And you believe it's in your child's best interest to adopt that agreement, right?
Yes, I do, especially with the school district, just because of the issue with bullying.
Okay. And you're asking the judge to enter that agreement today, right?
Yes, I agree.
Nothing further, Judge.
All right. Mr. Gladen, do you have any questions? And let me, court has one for you. Do you believe this agreement, this recommendation is in the best interest of your child?
Yes, Your Honor. I believe this agreement is fine.
All right. All right. The court finds this agreement between the parties, this recommendation to be in the best interest of the minor child. The court will currently adopt the same. And there's no need for another review date at this point in time. Is that correct, Mr. Bruce? So hopefully the parties can move forward and raise your child together. Anything further, Mr. Bruce?
No, Judge. Thank you.
All right. Mr. Gladen, do you have anything further? Any questions, concerns?
No, Your Honor. Thank you.
All right. Good luck to both of you. Good job. Thank you, Ms. LaPrade. Court will adopt the recommendation.
Try to make.
I
can't make a payment while I'm in here.
Hey, you haven't made a payment in 3 years, sir. Are you trying to tell me that you've been in rehab for 3 years?
No, no, I have not.
Okay. Well, the last payment was in 2021.
All right. I've had some troubles that I'm going through with my drug rehabilitation, and it's doing the best I've ever done right now. I just asked for one more chance. I mean, I'll come to the court.
No, sir, you're out of chances. You can ask the court for chances, but with the friend of the court, you're out of chances. We've got a first finding a day contempt with 16 days. I'm going to ask for all 16 days, and I want $1,000 bond. You don't have to agree with me. You can ask the court for another chance. I'm ready, Sarah.
Okay.
Right. For the record, Mr. Papen is appearing via Zoom from the Monroe County Jail. Have been arrested on a bench warrant. Also present is Monroe County in front of the court. Monroe County in front of the court. Patrice Patrick. Mr. Papen, are you being held in jail on any other warrants other than the front of the court warrant?
No.
Okay. Where do you? What's your mailing address?
It's at.
How long have you been there?
I've been at Ty's Recovery's house since I got out of rehab, and 2 months ago.
All right. The address we have on file for you is you want your items mailed to you at this new address. You need to provide the front of the court in writing with your new address.
Okay.
Okay. So Ty's house is downtown Monroe, correct? You can actually walk to the courthouse from there, correct?
Yeah, it's right on Navarre Street. I'm doing really good, actually.
So why would you come down? And if you knew you had a child support obligation, why would you come down to the front of the court and talk with your caseworker and tell them that you're in Ty's house and you're going through rehab and you're looking for a job and rather than sitting on your hands?
Well, I am actively looking for a job. That's part of the program.
Mr. Papen, the question was, why, if you've been there for 2 months, why don't you come down to the front of the court? You could walk and tell the front of the court what's going on with your life.
I was just trying to get my life together, I guess.
All right. Ms. Patrick, can you provide the court some background information regarding this case in terms of the arrearages, the last payment made?
Yes, Your Honor. Good morning. We have a warrant for Mr. Papen's arrest. We would ask that you rescind and cancel that. That is going to be in your on-base queue. This is a 2009 case, so it is arrears only. That both the children of this case have emancipated. The arrears on the case are $8,286.90. We last received a payment from Mr. Papen on May of 2021. That came from unemployment, so we had withheld that from his unemployment check. As the court stated, we have not seen or spoken to Mr. Papen since
approximately January of this year, and he failed to make a hearing in February, and they weren't issued. We do have a first finding of contempt, Your Honor, with 16 days balance. I believe at this time, the front of the court is going to ask for that full 16-day balance and $1,000 bond.
Right, do you understand the recommendation, Mr. Papin?
Yes, Your Honor. I ask that you take in consideration that I finished rehab and that I'm at Ty's three-quarter house doing what I'm supposed to be doing, actively looking for work, and do have a job interview today at 4 o'clock at Dave's Lawn Service.
Okay, well, it's a pretty heavy rain today. Mr. Papin, the primary concern is you've been here locally. You're not out of town in a rehab facility. You could have walked down in front of the court. In front of the court is a 4-page list of employers that are screaming for employees. I can get your job today, Mr. Papin. Michigan Bar is hiring dishwashers. All the lawn services are looking for people. Mr. Papin, you've sat in your hands. You've done nothing.
I have been looking for work. I would like to report daily if I could, as long as, and I can show you that I'm reporting and making these obligations to look for work.
Mr. Papin, you provided the court with no reasonable explanation of why you wouldn't walk down in front of the court, talk to their caseworker, ever since you've been in Ty's house. All you had to do that, you could walk down there. They could have helped you find a job. You could have avoided being arrested on the bench warrant. You got to be proactive. You're sitting on your hands. You got $8,000 of urge. You made no effort. So,
I'm trying.
Do you have anyone that can post a bond on your behalf?
I have nobody in my family besides me.
Okay. And when's the last time you were employed?
I'm unsure, Your Honor. I've had trouble with drugs in the past, and I'm doing the best I've done, to be honest with you.
And that's fine. I'm glad that you were remaining sober, Mr. Papin, but you've got to take care of your obligations. You could have very easily done that by simply walking out of the front of the court and then talk with the caseworker, find out, okay, what's the status of this matter? You knew you had child support obligation, and if you're not having any consequence in front of the court, there's a really, really good chance there's a bench warrant out for your arrest. You could have avoided putting yourself in this situation, Mr. Papin. You did it yourself. You could have been proactive.
Is there any way that I can report daily? There's no way I can report daily?
You haven't reported in a couple of years, Mr. Papin.
Well, I'm doing the best I can. I'm at
Understand.
Ty's recovery house.
That's Mr. Papin. I keep repeating myself. Please. That's wonderful that you're remaining sober, but you're not taking care of business. You could have walked down to the front of the court and simply said, I'm doing well. I'm at Ty's house, and they could have helped you find a job. So do you have any family or friends that they can reach out to that can post something less than $1,000 bond?
I don't have anything. I mean, I have nothing. I'm trying my best.
Right. I mean, you're not doing, again, you're staying sober, but that's all, Mr. Papin. So when were you arrested? Were you arrested before or after midnight?
I was arrested yesterday at 9:30 a.m.
9:30 in the morning?
Yes.
And what was the nature of your contact with law enforcement?
My friend was on the phone while she was driving.
Okay. So you arrested yesterday at 9:30 a.m. Is that correct?
Yes.
Okay, so you're entitled 2 days credit. Obviously, the original finding of contempt was 45 days. You've already served 30 days, Mr. Papin, and you could have avoided these other 15 if you simply have paid attention to this obligation. It's not going to go away until the $8,000 is paid. You're not going to go away, and you need to make some effort. So the court's going to file the recommendation. You're to serve 15 days in Royal County Jail. You're given credit for the 2 days you have served. The remaining balance of 13 days immediately, but you can release bond posting a $500 cash bond. So if you can reach out to the girlfriend that was talking on the phone when you were stopped, see if she can post a $500 cash bond. You can be out this afternoon. Otherwise, you serve the next 13 days in jail. If I'm going to give you a date to come back sometime in July to talk to the front of the court, and you better come back with a job. When you get out of jail, come to the front of the court. They have a 4-page list of employers that are screaming for employees. Good paying jobs, Mr. Papin, can make it real easy for you. Can help you out.
I could be working right now.
Ms. Patrick, what do you suggest for a review date?
July 30th, Your Honor, at 10 a.m.
Mr. Papin, you're to appear before the front of the court for review July 30th at 10 a.m. You send over to the jail. You get a copy before you release. And what do you want? Do you want copies ordered mailed to Ty's house or to the Heist Road address?
It don't matter.
All right, July 30th, 10 a.m. The records reflect Mr. Papin has exited the hearing room without being told we were done. Right. Deputy Peters, good morning.
Good morning, Your Honor.
How are you?
Good morning, Mr. Patrick. Good, sir. How are
Good
you?
morning, sir.
Wonderful.
Good.
For the record, this matter is before the court on the plaintiff's motion to review child support and other relief. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff petitioner Jennifer Crowley-Duso, and Ms. Crowley-Duso is present. And this Zoom hearing, also the defendant, Father Derek Duso, is also present. Good afternoon, everyone.
Good afternoon.
And the parties have confirmed with Mr. Pratt for the front of the court. This afternoon has provided the court fine recommendation that child support be modified. It appears to be in the nature of an increase at commencing May 1st of 2024. Defendant father shall pay child support in the amount of $2,124. It's broken down as base support of $2,083, a $13 credit, health insurance credit of $54 ordinary medical for a total of $2,124. It's based upon the plaintiff mother having 287 overnights, defendant father having 78 overnights. Uninsured medical expenses shall be shared as follows. The plaintiff paying 20%, defendant father paying 72%. Further, to recommend that the court order that the father reimburses portion of their extracurricular activities for the children within 30 days of today's date. Further, finally, that each party shall claim one minor child each tax year as a dependent. Mother will claim Kimberly, father will claim Michael. The children is noted to have a band trip to Universal Studios. The trip is not mandatory. However, father is paid for the trip out of the same situation for 2022-23, and the party shall share equally the cost of that band trip. That is a recommendation. Mr. Gorski, is this recommendation agreed with your client this afternoon?
Yes, Judge. I think the 30-day reimbursement is from today for, well, Dad does owe Mom some money, but I think the agreement is just that within 30 days of her providing proof of payment, he will pay. My client's shaking her head no.
He caught up the last year's band payments.
Oh, okay. He doesn't owe her any money.
No, those have been caught up. It's just going this school year going forward.
So going forward within 30 days. Yes. Thank you, Judge.
Okay. Right. With that clarification, Ms. Zagorski, this recommendation is agreeable with your client. Is that correct?
Yes. Thank you.
All right. To Mr. Duso, good afternoon. Do you understand the recommendation?
I do.
Do you have any objection to the court adopting this recommendation?
I do.
Okay.
This is not a mandatory extracurricular, or it's not an extracurricular that I agree to. So in our agreement, it says that for extracurriculars that I agree to, but I have not agreed to this one. This is not an extracurricular.
Okay, you're referring to the band trip. Is that correct? The band trip to Universal Studios?
It is a trip that the band takes the kids to go to Universal Studios, but it has nothing to do with band. Last year, I was under the impression that they were going to go and play in a parade or do work camps or something of that nature, and they did not do anything at all with their instruments or anything band related whatsoever.
It appears that the last order by the court, November 14, 2023, it says all extracurricular activities are agreed to shall be paid equally by the parties. Ms. Gorski, if Mr. Duso does not agree to, I guess what is this, a future band trip? Is that correct? Is that later this summer? Or is it in the fall, or is it holidays?
Next spring, Your Honor.
Okay, so obviously if Mr. Duso does not agree to it, he should not have to pay any portion of that.
Yeah, so here's the thing, Judge. The children are in band. That order that you referenced does refer to band camp. That's the summer band camp. My argument to why the trip to Universal should be a part of those agreed upon extracurricular, and just to be clear, Mr. Duso does agree that the children can participate in band, and they have, and he's paid for it. My client just confirmed that he paid the fees that were accrued last year. The camp itself is $2,600. It's at Universal Studios. The children attend workshops. It is part of the band program. He has agreed that they can be in band. He has paid for it in the past. And it appears to me like he's punishing the children because my client brought him back to court for more child support. Mr. Duso is making more money than he did last year. That's why his child support went up. He's making more money than he ever did. And arguably, I could assert that he should pay 72% of the cost, but the parties have agreed that they share those costs. And it's unfair to the children that he's not allowing them to do this now when he has in the past. This is retribution for returning to court for child support, and the children shouldn't have to pay the price because Mr. Duso's angry.
Well, the fact they're participating in band at school as a extracurricular is one thing, but going to Florida Universal Studios is that's certainly, and even this recommendation is not mandatory. And I understand even though you paid it last year, it's not required that you pay it every future year, Mr. Gorski. So the court would not order him to pay that if, in fact, he does not agree to the kids participate.
Said they could go.
The last order says pretty clearly all agreed upon, all extracurricular activities that are agreed to shall be paid equally.
Well, but he
do
did
so.
say that they can participate in band.
He said they could go, just won't pay for it.
Well, participating in band is one thing. Is it mandatory? Will they be removed from the band team if they don't go to Universal Studios, Ms. Crowley?
No, Your Honor, they won't be removed, but they will be doing like camps while they're there, learning different things. Mr. Dusso said that they could go on the trip. He just doesn't want to pay for it.
Well, based upon the last agreement of the parties, the court hard pressed to order him to pay for it if he is not agreeable they participate in that. That's your only objection to this recommendation, Mr. Dusso. Obviously, you're going to disappoint the children if that's your position, and obviously it's going to create problems because mom's going to say, "Well, I can't afford it, and dad can't help me." And I mean, really, is it? Do you want to create problems for your 12-year-olds? You know what? You know better than the court does if it's important to the children.
Your Honor, we can do other things. Family vacation, perhaps something. Last year, like I said, they went, and all it was a trip for them to go to Universal Studios. Had nothing to do educationally, anything. So it was $2,600, $1,200 that I came out. Missed a couple days of my vacation with them, and for them to just go to a theme park for 5 days on their own.
Why don't you join them? Have you ever thought of joining them?
No, Your Honor.
Maybe mom can stay home and you can spend that time with the children at the band camp Universal. That might be a special time for dad.
I've worked, Your Honor.
I'm sorry?
I've worked, Your Honor. And no, then that's
Okay.
another ticket for me also.
All right.
Your Honor, I'm heartbroken for these children, and as you can see, my client is as well. He's making more money than he ever made, and I just feel like this is unfair to the children. He can afford it. He makes more in retirement than my client makes in her current salary, and he has another full-time job on top of that.
I'm just looking at the last order, Ms. Sikorsky. Says any all extracurricular activities are agreed to shall be paid equally by the parties. If he's not agreeable to the band camp, it's not mandatory they participate in that.
But he does agree to band. In fact, that same order says that the children are with him until 2 weeks prior to school, starting on a Sunday before band camp. This is something that he agrees to. It was incorporated.
Is this part of band camp? In other words, a band camp is presumably something at school, correct?
It is part of a band program, and they do workshops. I mean, I don't think that the children are punished because a parent can't afford to send them, but Mr. Dusso can afford to pay half. It's not even 72%, it's half.
Okay, I know he's opposed to it. So maybe Mr. LeBreton can revise the recommendation. Is the remainder of the recommendation acceptable, Mr. Dusso?
The remainder is yes.
All right. I guess we can just delete those last two sentences referring to the Universal Studios band
Yes,
trip.
sir. They're never going to get to go on a trip now.
Of course, again, hate to see there's the problem with the kids because mom's going to blame dad and the kid's going to have an issue with dad, which is very unfortunate. I don't know how you address that with the children. If they've done it in the past, they're looking forward to it, and most of the other band members are going. I don't know how the two of you as parents are going to address that.
Your Honor, I would never make this dad's fault with the kids because I go above and beyond to make sure that they don't know what's going on. But my concern is that now because he doesn't have to pay for this, they're only going into 8th grade. There are going to be school trips the next 5 years. There's going to be band trips the next 5 years. So now because he doesn't got to help with this, he's never going to help with any of those. So any trip that they go on is going to have to be 100% out of my pocket.
Don't they have fundraisers? Are the students involved in fundraisers to help defray the costs?
No, not for the junior high band. No.
Right.
I don't know about high school. They're only going into 8th grade.
All you can do is delicately suggest to the children to reach out to their dad to see if their dad will help them. Because you can't afford it on your own. Maybe they've got to reach out to dad. Maybe that's the answer. I don't know what to tell you, Miss Crowley.
I just don't think it's fair.
Yeah, life's not fair, but that's what the two of you agreed to back in November 2023. I don't think
No,
the
I
band camp is the
understand.
same as a Universal trip, Studios trip.
It was not the intent that Mr. Dusso would be able to veto activities for the children. That was not the intent. Extracurriculars, yes. So if my client said, hey, Michael wants to play hockey and I want you to pay half, Mr. Duso could say, I don't agree to do that. But these children are in band. If mom said, I want Kimberly to become an equestrian and I want you to pay the farrier and boarding and for feed and for vets, he could say, I don't agree to do that, but not band.
And when he agreed to band last year, back in November when we went to court, they were already planning on going on the trip for last year and he was already making payments on it. So I don't understand why he thinks that this isn't a part of it.
Yeah, I'll put you back our room and you can discuss it further, Ms. Crowley, if you want. I can't tell you why he can't understand it. I can't either. I'm just telling you, the trip to Universal and the course meeting is not part of the school band camp. If that's a local band camp, is it not? They're not not getting on a plane and traveling the distance to another state to participate.
No, they'd be doing workshops there.
I'm sorry. Again, unless dad will agree, and the children should reach out to their dad and just tell them that you can't afford it. And if that's important to them, they should reach out to their dad and tell them how important it is to their dad. Anything further, Mr. Gorski?
No, thank you, Your Honor.
All right, Mr. Duso, give us some serious consideration. I mean, you know better than anyone if this band is important to your children, especially, I guess, some of the rewards they look forward to as being a member of a band is taking some of these trips. So please keep an open mind, and obviously you can always reconsider and help out the children. Maybe the children need to talk with dad. Ms. Crowley, that's what the court suggests, but the court's not going to order him to do so, even though he might have done so in the past. The court is not, this is not part of, quote, band camp. If Ms. Zagorski, if you want to provide some additional information that this is part of band camp, and again, I presume there's some local band activities nearby here in Michigan, or part of the school program, but this is again, is not a mandatory part of that band. Extracurricular to travel to Universal Studios, so the court's not going to order father to pay it. The remainder of the recommendation, the court will, however, will adopt. Anything further, Mr. Duso?
No, Your Honor.
All right, that will conclude this matter. If you could revise your recommendation, Ms. LaPrade, please.
It's in the queue, Your Honor, and I'll get rid of the old one.
Thank you. I don't think that's what they agreed to.
You're absolutely correct, but I can totally understand why mom is like.
Well, the problem is it's going to create problems because mom's going to, can't afford it.
They can't go, and they're gonna wanna know why. Well, yeah, I'm judging, she can't back and wide open.
Of course, you should say I can't afford it and you got to talk to their dad.
Yeah,
To help out. I mean, that's.
I do like how you put it back on.
eh.
Yeah,